All right. Thank you, everybody. We are going to get started here. I appreciate each of you for attending. Welcome to today's Author Meets Reader Symposium on Natural Property Rights, published this spring by Cambridge University Press, authored by Professor Eric Claeys. We're delighted that you could come. My name is Garrett Gillespie. I'm the symposium editor for the George Mason Law Review, and I will be moderating, emceeing, pick your term. I will be moderating or emceeing today's event. Before we get started, a couple of housekeeping items. First, today's symposium is being recorded. The recording will be posted on the Scalia Law website as well as the Pepperdine School of Public Policy's website. Second, we will have a reception that begins approximately 15 minutes after this event ends, the panel portion ends, in the Leadership Center of Hazel Hall, which is room 150. So that's going to begin at 4 p.m. We also have student volunteers here and out in the hallway, and we will be able to direct you to the Leadership Center after this event. The symposium has been made possible by 3 institutions. The symposium speakers, Professor Claeys, and I would like to thank them for making this symposium possible. The symposium is being hosted by the Antonin Scalia Law School at George Mason University. Scalia Law provides students a top-tier legal education right next to the nation's capital. Not only do Scalia Law students master legal doctrine, they also learn to study doctrine with other disciplines such as economics and philosophy. From 2025 through 2028, Scalia Law graduates will serve in 72 federal court clerkships and 30 state court clerkships. Scalia Law is also Washington's School for Civil Discourse. The school's faculty exposes students to all viewpoints along the legal and political spectrum, and a Scalia Law education teaches students to join contemporary debates in a civilized and respectful way. The symposium is being co-sponsored by the Pepperdine University School of Public Policy. The Pepperdine School of Public Policy prepares its students to lead with moral clarity. At a graduate school with the nation's highest-ranked public policy program rooted in Christian values. The school's Master of Public Policy prepares leaders to apply the history and philosophy of American public policy to enact positive change throughout the world. Like Scalia Law, in an era of polarization, the Pepperdine School of Public Policy prepares students to see an issue from all sides with firm dedication to freedom of intellectual thought. Finally, the George Mason Law Review. The Law Review is Scalia Law's flagship student-edited law journal. The Law Review operates as a traditional student-run law review featuring scholarship by judges, law professors, practitioners, and Scalia Law students. Nick Rodriguez serves as the editor-in-chief. We also have our immediate past editor-in-chief, Pete Tucker, in attendance. And Professor Claeys is the faculty advisor. Remarks from the participants in today's symposium will be published in a forthcoming issue of the Law Review. Today, I want to introduce our first speaker, Julia Mahoney. Professor Mahoney is the John S. Battle Professor and Joseph C. Carter Jr. Research Professor at the University of Virginia School of Law. She teaches courses in property, constitutional law, government finance, and nonprofit organizations. Professor Mahoney has authored numerous law review articles, including The Emerging Law and Political Economy Movement, co-authored with Scalia Law's own Professor Todd Zawicki, Takings and Implied Causes of Action, and my personal favorite, Cedar Point Nursery, and the End of the New Deal Settlement. Professor Mahoney is also an elected member of the American Law Institute and serves as an advisor to the Restatement of Property. Professor Mahoney, the floor is yours.
Thank you. Thank you so much. So I'm thrilled to be here. This book is a magnificent accomplishment, and it has been many years in the making. And I think it's fair to say that I have interacted with Professor Claeys on many occasions over the course of this, and I have encouraged him strongly to take a bold view, a bold approach. And I am very pleased that he has done so. So natural property rights suggests that a just system of property, as Professor Claeys puts it, protects people's rights to use resources and also orders those rights consistent with natural law and the public welfare. Now, that is a fairly aggressive claim because, in part, as Professor Claeys notes, natural law has had a bad odor to it, at least in legally sophisticated circles, for some decades now. So one of the ways, I think, in which natural property rights represents a significant contribution to the literature on property law, including the literature on constitutional constraints on government action, and a book that was going to be, I think, extremely helpful to scholars and students and judges and litigants and regulators and policymakers. One of the reasons that this book is so important is that Professor Claeys is willing to say flat out that a natural law is not dead, that it has never been dead, that it is everywhere in effect in property law and property rights, and then explain some of the ramifications of the fact that natural law is actually with us. This is not simply a matter, Professor Claeys argues, I think persuasively, not simply a matter of labeling. It is a matter of how our system of property rights works and also is essential to understanding where property may develop as a field. As Professor Claeys notes, what he is trying to accomplish in this book, and I think does accomplish, is something of a reclamation project, addressing skepticism toward the idea that natural law is important to property. So how is it that natural law ever got forgotten in Professor Claeys' account? There's a bit of a misunderstanding. There arose this idea that natural law was all about religion, all about some sense of an ordering of human affairs that originated with commitments to what is and is not true about the divine world, and that over time, the idea arose that one couldn't possibly have a system whereby the divine or people's ideas about the divine would actually order affairs here on earth. And that morphed into claims that law, including property rights, was a matter of proclamation by an earthly sovereign. Law is whatever it is that authority, public authority, says that it is. Of course, as Professor Claeys notes, there were immediately a number of qualifications to this, namely that, well, there must be, social facts matter, and so forth. Law is, of course, embedded in society. Who could disagree with that, and so forth. What Professor Claeys, I think, does an excellent job in this book in making clear is that when one actually looks at the leading cases in property law, what one sees is not a lot of desiccated rules that are the result of legislative action or simply one court decision or another, but what one sees is a rich system embedded in social welfare, embedded in the way that humans actually interact with one another, and a rich system in which property rights take a leading role in promoting human flourishing. Now, why does this matter? Why do I say at the outset that what Professor Claeys has done is way more than simply affix labels? This is not a book that is, at its core, a taxonomy explaining to us that what many people think of as positive law is actually a manifestation of natural law. I think the key to why Professor Claeys' reclamation project of natural law, as he calls it, is so important can be found on page 170 of his book, when Professor Claeys says that many see natural property rights as being grounded in a kind of libertarian sort of framework whereby individuals have all sorts of rights to say no, and that when we figure out when we try to figure out what how society is ordered, we think of government power as being restricted by the content of these individual property rights. Do I have this roughly correct? And that really we need to think about things as much more of a rich and complicated system. It is not that government has power to do whatever it wants and then oh yeah. Every once in a while we say, whoa, but people have property rights, and so that limits government. What is actually going on, how we really need to think about this, Professor Claeys, to me anyway, suggests, is that government power is constrained itself by the need to have a flourishing society. And that the fact that government power is not omnipresent, it is not true that when governments want to do things, they can do them unless there's some kind of pre-existing right that stops them. It's that government powers in themselves are limited in crucial ways. So when we think about, for example, the power of government to regulate, we must understand that those powers are grounded in authority of the government, legitimacy of the government, to make for a flourishing world, one where people can develop, one where people respect each other. That means that when we think about, for example, the basic police powers, powers to promote public health, safety, and up to a point even morals, we have to recognize that those powers are constrained. And the fact that those powers are constrained means that it is the constraint of the government powers that we must look to, at least to a significant degree, in terms of understanding the contours of individual rights. Going forward, I think, when I contemplate how property law, particularly the constitutional law of property, may develop, I suspect that there will be more attention paid to what the goals of the U.S. Constitution are and how the United States Constitution contemplated vigorous, strong governments, both a strong central government at the national level, one that has enormous state capacity to provide for national defense and to regulate international commerce and so forth, and interstate commerce, and that the United States Constitution, together with the roughly contemporaneous state constitutions, also contemplated there being very broad police powers on the part of state governments and their various components. But what was not contemplated was a government that could, in effect, simply award the winners, whoever is the most recent winner of the election, for example, carte blanche, limited only by some sort of individual rights. Instead, I think that we are moving toward a conception of the United States Constitution as providing for governments where government power, when it is exercised, will have to be justified in ways that are deeply rooted in the natural law tradition, deeply rooted in a way, even if those words, natural law, are not used, and they often aren't. When I think about, for example, the Supreme Court's most recent takings cases, we don't see the phrase natural law used, but we see a lot of natural law concepts, a lot of ideas that it is the promotion of the public well-being that provides the legitimacy for the government. So I think, just trying to sum up here, that this book is going to be extremely useful in terms of, in particular, its rich descriptions of the most important property cases that will give us, I think, much more of a complicated and nuanced understanding of how courts throughout American history have actually proceeded in terms of finding the contours of government power, of pricking out the contours of government power. The result of those explanations, of those findings of government power, will often then end up giving us information about so-called natural property rights. What Professor Claeys has done, I think, is to focus our attention on the fact that this isn't a matter of trying to figure out what the actual natural property rights are, but more looking at a system where property rights and government power go together. So thank you very much, and I look forward to a spirited discussion.
Thank you, Professor Mahoney. Our next panelist is Joseph William Singer. Professor Singer is the Bussey Professor of Law at Harvard Law School. Professor Singer teaches and writes about property law, conflict of laws, federal Indian law, and legal theory with an emphasis on moral and political philosophy. He has published more than 90 law review articles and multiple books and case books, including Choice of Law, an experiential learning approach in property law cases, policies, and practices. Professor Singer.
I want to start by saying that I find a lot to value in the natural rights approach that you've taken in the book. First, I think Professor Claeys is absolutely right that asking what the law should be requires identification and analysis of values, and not just promotion of the general welfare. Indeed, we cannot even conceptualize what it would mean to promote the general welfare if we did not have a sense of what the word welfare means. That requires us to know what is good for us, and we cannot know that unless we can identify our legitimate interests. Determining whether an interest is legitimate requires a value judgment, and so does deciding when the law should impose enforceable duties on other people to respect those interests. Second, as Professor Claeys argues, values are objective in the sense of being categorically different from mere preferences. We can consider, reflect, and reason to determine when we are justified in making demands of each other. Human experience, reason, persuasive argument, and reflective consideration enable us to identify values that can serve as contextually basic foundations for both moral and legal reasoning. Third, I agree with Professor Claeys that normative analysis of law requires practical reason. That means consideration of the consequences of alternative rules of law, the social context in which legal rules hold sway, and the need to shape legal rules in ways that are wise, fair, and practical. At the same time, I have some qualms about the constraints that the natural rights approach appears to impose on law. First, values change over time. I'm wary of using the term natural to describe either rights or values. The term suggests that human values based on reason never change. But our values and our property law have changed dramatically over time. That's partly because social conditions have changed, but it's also partly because our values have evolved over the course of history. Shortly after independence, the states banned quit rents. Over time, we moved from a fencing out system to a fencing in system. We gave married women the power to control their own property and an equitable share of their husband's separate property on divorce. We promoted and then banned racial segregation in public accommodations and housing. We enacted single-family zoning, but today both liberals and conservatives are coming to see it as an impediment to solving our housing shortage. Many states have abolished the rule against perpetuities, and we invented condominiums and homeowners associations. We securitized subprime mortgages and then banned them. Some of these changes were based on preventing negative externalities, but I believe all of them reflect changes in values as well. And while some changes in values may be regrettable, many are the result of moral learning and are to be encouraged. Second, democracy, I believe, is about collective self-government and not just protecting rights. It's about government of the people, by the people, and for the people. If property law must protect natural property rights and nothing more, then there is not much room for democratic governance that shapes property rights for the benefit of the community. But democratic self-government is a mechanism we use collectively to choose the laws that govern our interactions with each other. Individual liberty is a core value we all share, but so is democracy. Is there a natural right to a building code, a housing code, condominiums, environmental regulation? Limiting democracy to protecting rights may limit the police power in ways that prevent us from solving serious social problems like climate change. Not everything government does or should do can be characterized as protecting rights. Not every legitimate interest deserves legal protection in the form of an enforceable legal claim that places duties on others. But government action to promote those interests may nonetheless be a valid purpose of law and government. In addition, property law is complicated, as my students realize. It includes much of the law school curriculum. First-year property encompasses trespass, nuisance, easements, covenants, future interest, mortgages, real estate transactions, leases, recording acts, marital property, tenancy in common, joint tenancy, tenancy with authority, fair housing law, zoning, regulatory takings. Upper-level property courses include partnerships, corporations, wills, trusts, real estate finance, negotiable instruments, banking, secure transactions, copyright, patents, trademark, publicity rights, bankruptcy, family law, land use regulation, environmental law, anti-discrimination law, tribal property. Now, most of these property rights would not exist without regulation. Indeed, legislation enabled us to benefit from these forms of property, and legislation is needed to ensure that they promote the general welfare. Statutes created the modern mortgage and shaped its terms. Securitized subprime mortgages had the minor side effect of wrecking the world economy. We enacted legislation to ban them. We did that partly to protect rights, but mainly to avoid the widespread harms of a property right that turned out to have toxic consequences for society. Third, I think we should focus not only on our rights, but our obligations. Consider the problem of the improving trespasser. This happens more often than you would think. In one case, because of a surveyor's error, the Coca-Cola company built a bottling factory on a lot belonging to somebody else. Traditional law would give ownership of the factory to the landowner as a fixture, or a court might order the building demolished as a continuing trespass. But many courts today have adopted the relative hardship doctrine, which involves a forced sale of either the land or the building. That doctrine is partly based on our abhorrence of waste, but it also rests on the notion that the landowner should have noticed a factory being built on their own land. Similar to the duty to mitigate damages in contract law, the landowner could have prevented the problem by stopping the construction at the outset. Similarly, landlords have the obligation to provide habitable housing consistent with the housing code and to rent property to tenants without regard to their race or religion. Owners have rights over their land and what happens there, but they also have obligations not only to non-owners and the public at large, but also to those who enter their land and conduct activities there. If natural rights makes us indifferent to the obligations we have to other people, it would limit rather than enrich our moral imagination. And I know Professor Claeys understands about obligations. I'm partly arguing that some rights come from thinking about obligations rather than obligations always being derivative of rights. Fourth, I worry that natural rights reasoning, if it's misused, could oversimplify hard cases and give us too much confidence in our own judgments. Professor Claeys rightly argues that rights should not be sacrificed to promote the general welfare. A free and democratic society that treats each person with equal concern and respect does not tolerate invasion of rights just to benefit the community. But on the other hand, Professor Claeys rightly acknowledges that practical reason is needed to specify the content, scope, and application of rights. Practical reason involves consideration of consequences, including effects on third parties. That may include, for example, creating a well-functioning private property system consistent with personal rights, like security and the free exercise of religion. If we are allowed to consider the consequences of rules in determining how much legal protection to give individual interests, there's a really fine line between sacrificing rights to promote the general welfare and defining the legitimate scope of rights so they do not harm the legitimate interests of others. Consider the case of an owner who sold a grocery store with a covenant prohibiting future use of the property for grocery store purposes. The owner wanted to protect his other store from competition, but the New Jersey court refused to enforce the covenant on the ground that it created a food desert that denied easy access to healthy food for the residents of a poor community. There is no natural right to have a grocery store in your neighborhood, yet empowering a grocery store to operate on the lot, despite the covenant, was necessary to promote the general welfare. Rights theories only work if we approach the question of rights with humility. We should be aware of our tendency to overgeneralize. The protection of one person's rights imposes vulnerabilities on others, and we cannot close our eyes to those vulnerabilities. That requires us to attend to both sides of contested questions. It requires us to exercise judgment. Philosopher Susan Neiman reminds us that no law applies itself, ever. It is people who will make moral judgments about what interests are legitimate, how strong they are, and when they should give way to the legitimate interests of others. I agree with Professor Claeys that values and practical reason are resources that help us understand the complexity of property law and help us shape it so that it promotes justice and fairness and liberty. But values and practical reason cannot make decisions for us. That burden is one that human beings can never relinquish.
Thank you, Professor Singer. Next up, we have Jessica Asbridge, who's an associate professor of law at Baylor University. Baylor University Law School. Professor Asbridge teaches property, federal administrative law, arbitration, and persuasive communication. She writes in areas of property law and administrative law with a focus on the takings clause. Some of Professor Asbridge's articles include redefining the boundaries between regulations and appropriations, private delegations and eminent domain, and tax forfeitures, and the excessive fines muddle. Professor Asbridge, thank you for being here.
Thank you. So Professor Claeys' book overall presents a clear and unified theory of property, touching upon both private and public law. And he also had excellent timing in terms of the release of the book, given that the U.S. Supreme Court in Tyler versus Hennepin County recently indicated that it was willing to look to sources outside of state positive law in defining private property. And some have suggested that natural law is perhaps what the court alluded to. I want to go a step beyond Tyler today, though, and look to what outright limits natural property rights theory would place on the police power and eminent domain power. That is, I want to look at the limits that a natural property rights theory would impose on those powers, basically functioning, to borrow another term from law and econ, property rules, in the sense that those limits are just going to bar government interference with property rights in certain cases. So the court's current takings doctrine is one of liability rules, meaning you can interfere with property rights, government, so long as damages are paid, whereas property rules, again, just to be clear, are going to outright bar those interferences in the first place. The court relies on liability rules to protect private property, freely allowing interference with property rights so long as compensation is paid, when regulations go too far, or there is an appropriation. Natural property rights theory would differ from the court's current approach, as it would simply outright prohibit government interference with property rights in certain cases. But I will show that, perhaps somewhat surprisingly, those property rules are generally triggered by defects in the political process. In other words, I think that the natural property rights theory is more focused on process than might be initially expected. And I'd also really, maybe perhaps during the question and answer session, like to get Professor Campbell's thoughts on the political process lens, given his writings on common good constitutionalism. So I'm going to focus primarily on the police power limits and set eminent domain to the side for the moment. And under this theory, there really seems to be an ends test and a means test. And the ends test is pretty deferential to government action. Perhaps in some cases a little too deferential to government action. And instead it is the means test that is doing much of the work and filtering out improper exercises of government activity. And ultimately, overall, the test is rooting out defects in the political process. So I want to start with looking at the ends of permissible government regulation. And Professor Claeys lays out 3 different permissible ends, and I want to start with harm prevention. So the natural property rights theory overall as to harm prevention, what do I mean when I say it's rather deferential? Well, Professor Claeys, he would find the end satisfied in Lucas versus South Carolina Coastal Council, perhaps, involving a South Carolina state law that barred the property owner from erecting habitable structures on his land. The law's purpose was to protect the barrier islands from erosion and destruction. Professor Claeys explains that in Lucas, it was at least conceivable that the act prevented Lucas's use of his shoreline lots from harming South Carolina's coastline. Also, natural property rights, it does recognize that what constitutes harm can change over time, noting that 19th century laws prohibiting alcohol were upheld as valid police regulations, but today seem draconian. Thus, as Professor Claeys observes, a political community can reasonably conclude, that alcohol prohibitions are necessary to prevent harm to its citizens, but those value judgments can change over time. The question I had almost was, are there any teeth to an ends review? And the answer is yes, there are. But I saw it most clearly where there are 2 uses pitted together. And when there are those 2 uses pitted together, that's where the concern arises about the political process defects. So to explain, a natural property rights theory, you can't just know what constitutes a harm intuitively. You have to look to those uses being put to property already in the community, and then seeing whether the use at issue is more intensive than others, beyond local live and let live principles, such that the use can be considered to result in harm. So I want to look at the Miller versus Schoen case, which can help to show where a harm might exist under a natural property rights theory. So in Miller, the Virginia legislature enacted a law to cut down cedar trees when they carried cedar rust fungus within 2 miles of any apple orchard. The facts of Miller are a bit unclear, and Professor Claeys himself notes this is a hard case. Assume, however, that the facts of Miller are such that there were numerous cedar tree groves in the area, and only 1 apple tree orchard, requiring the cutting down of all of the cedar trees for that 1 apple tree orchard suddenly would no longer be remedying a harm, an invasion of a property right. That is because a property right must serve the interests not only of a specific claimant, but also of everyone else in the community under this theory. Preserving the apple orchard while destroying the cedar tree grove would be, in effect, allowing the wishes of one to control a whole community. In such a case, the regulation should simply be invalid, a property rule. And this may gall some who would prefer to let the legislature decide whether apple orchards have more social value to society than cedar trees. Yet in such a case, the legislature simply cannot be trusted to exercise their discretion in a principled way. And throughout the book, Madison's theory comes in. The Federalist Papers are referenced a few times. And Madison observes that the answer to this issue is because the reason of man continues fallible. But a strong connection subsists between man's reason and his self-love. People's preferences for what they find good for themselves distort their opinions about what is good for the community or for other people who have different preferences. So overall, the ends test from a harm perspective, to me, seemed less about focusing on singling out minorities and more on ensuring that the legislature is, in fact, acting for the common good. In this way, a natural property rights theory, contrary to some have viewed it or categorized it, is decidedly not counter-majoritarian. So the other ends that I want to focus on also is the reciprocity of advantage. And legislatures can also act under Professor Claeys' theory where there is this reciprocity of advantage. This idea is it kind of flows from this idea that government acts to expand use in a community. You are allowed to act to expand use in a community. And according to Professor Claeys, reciprocity of advantage only works when it is clear that people's uses aren't different and incommensurable. That is, that they are likely to pursue the same interests by similar conduct. So a good example of reciprocity of advantage that he gives is forced pooling. Yet in other places in the book, the reciprocity of advantage category seems much broader than just expanding use for all members of a community through regulations. So he kind of makes two moves throughout here as to the reciprocity of advantage section. He suggests that assembly cases, like those for pipelines and economic development, might not be proper exercises of the eminent domain power at all. Leave that out. But they might be valid police power actions. And I found that kind of reclassification really interesting. He suggests that reciprocity of advantage may exist in such cases where supercompensatory damages above the fair market value for the property taken or destroyed is paid. So for example, with respect to Kelo, at one point he suggests that extraordinary compensation for the condemned property could secure the property owner's genuine advantages. So it is the notion of supercompensatory damages as sufficient to constitute a reciprocity of advantage that to me seemed to push against the overall thrust of the natural property rights theory as I understand it. The purpose of property is to facilitate use and to a lesser extent enjoyment, to allow each to pursue their own ends with a domain of discretion largely free from governmental interference. So although government can intervene under the police power to secure reciprocities of advantage, the issue with such condemnations is that they replace the current uses being put to the property in the community and replace them with entirely new uses. Such condemnations displace property owners from their homes and their businesses entirely. And that displacement also means that they will not be permitted to enjoy the benefits of the economic development project itself, such that they do not result in any implicit in-kind compensation. And courts, they can't value the subjective losses and dignitary harm that displacements due to condemnation cause. Such supercompensatory relief is also still, important. Let me put it like that. So such supercompensatory relief is still likely far lower than the value of the property after the project. So those post-condemnation gains in fair market value flow to the private party as opposed to those who are displaced, and the private party will enjoy the benefits of the condemnation, resulting in a sort of forced transfer of wealth. In short, by allowing supercompensatory relief to broaden the category of permissible reciprocity of advantage actions, then the theory is moving away from the notion of property rules in this context and towards liability rules. Economic development condemnations especially, however, are at odds with the uses already being put to a community, and significant issues with valuation exist, such that property rules seem required. And from a process-based perspective, such supercompensatory relief tends to weaken political opposition to condemnations, making the political process even more suspect. Now, despite the ends by which government may act being rather broad, the means test would be where most of a court's focus would be. Government should show that the restriction is reasonably necessary to protect the equal rights of citizens. Although I'll note at one point in the book it talks about it being indispensable to the project. And those restrictions must be enforced even-handedly. Specifically, if authorities cite some putative harm to stop some instances of an activity, but leave unregulated other instances that produce the same harm, the disparities make less credible the government's claim that it is trying to prevent harm. So ultimately, by looking at the means, that provides the court with insight about the ends. The court has a back door to kind of flush out, inappropriate purposes. And the necessary test would also foil the economic development taking at issue in Kelo. The Italian Dramatic Club, he has an example about that and how they actually redid the plan for the club. Even they could have done that for the homes as well. So ultimately, I think it is the scrutiny of the means that may result in the most significant limits to police power regulations. And the scrutiny of the means is looking for defects in whether a taking is necessary and is applied even-handedly, which at its roots has a process-based idea. Ultimately, Professor Claeys' natural property rights presents a unified theory on its treatment of property rights between private parties and as to government. That by itself is impressive. But it also manages to impose some real limits on government power without just looking to the impact on economic value or weighing social value. Instead, it recognizes throughout that differences are to be treasured, are a hallmark of freedom, are an objective of our government. But those same differences can form factions, and it is that concern that requires the inclusion of property rules in a coherent constitutional jurisprudence.
Our next panelist is Judd Campbell, who is a professor of law and Helen L. Crocker Faculty Scholar at Stanford Law School. His academic focus is constitutional history and First Amendment law. Professor Campbell has published numerous law review articles, including Natural Rights and the First Amendment, The Emergence of Neutrality, and General Citizenship Rights, all published in the Yale Law Journal. Additionally, he published Determining Rights, published last year in the Harvard Law Review. Professor Campbell, thank you for being here.
All right, thanks so much. It's really great to be here and have a chance to engage with this wonderful book. I'm a constitutional historian, and a lot of my work is focused on how earlier generations have thought about ideas of natural law and natural rights. So although Professor Claeys' book is not focused on history, and in fact, it's not even purportedly focused on American law, the arguments that he makes throughout the book really resonate with what I study. So in my time here, I want to begin with just a couple of general comments about natural rights and natural law from a historical standpoint, and then mention a couple of ways that we can get a better appreciation for the arguments that Professor Claeys is making and perhaps critique some of those arguments. So let's just start with two general observations about earlier understandings of natural law and natural rights. The first point is that the most important function of natural law and natural rights historically was not to supply a body of private law. So rather, the most important function of natural law and natural rights was to legitimate and structure governmental authority. So in late 17th century England, for instance, the idea of natural rights was used principally to justify parliamentary authority as opposed to the alternative theory of the divine right of kings. And then in the late 18th century, Americans similarly argued that the retention of their natural rights required that the people themselves maintain control over those rights, that they had to consent to restrictions of those rights, rather than being subject to laws imposed upon them by an unrepresentative foreign government. Now, notably, these laws included not only statutes, but also common law, which was thought to have been popularly accepted through prescription, through common practice. Natural law and natural rights did have substantive content too, and that's what I'll turn to next, but it's worth underscoring that their most important function historically was one that linked the retention of natural rights to the principle of Republican self-government. My second general observation about natural law and natural rights is about the substance of those rights. And here I want to reinforce a point that Professor Claeys makes throughout the book, and that is that these rights were legally underdeterminate. So natural rights were thought to be human liberties that were circumscribed by natural law and also by positive law that had both obtained the consent of the people themselves and also that promoted the common good. And then natural law was understood as a set of principles of reason and justice and morality, rather than as a set of legal particulars. So as Professor Claeys emphasizes throughout the book, these rights generally required specification or determination before they could become conventional law. This is a principal reason why natural law and natural rights were able to serve as axioms for several centuries. Reason alone could only get you so far. That meant that there was room within rights discourse to put forward a variety of different positions, which meant that in an important sense, natural rights were a durable grounding, a sort of common denominator of constitutional and legal argument. This is what allowed them to survive, was their flexibility. The underdeterminacy of natural law and natural rights also helped jurists view reason and custom as working together as the twin pillars of the common law. So the common law not only reflected the will of the people, as I was mentioning a moment ago, it also reflected the lessons of experience and the professional discernment of legal experts. Now, of course, legal realists in the early 20th century abandoned this idea of popular consent, abandoned this idea that popular consent and experience and reason all worked in harmony, just as they had abandoned the idea that there was anything natural about these bodies of law or bodies of rights. And that that shift is in fact reflected to some extent in this book. So although to a significant degree the book is offering a synthetic account of American common law, the law of property, Professor Claeys pitches it as being entirely based on abstract reason, as being divorced from the positive law of any particular jurisdiction. Now, maybe I just have a sort of historian's version of Stockholm Syndrome here, but I do worry about how viable it is to rely just on reason alone. And this dovetails nicely with Professor Asbridge's comments just a moment ago. How much can we rely on reason alone without accounting for features of the society and features of the institutions that are used to instantiate natural law and natural rights? And to make this point more concrete, I want to just focus on two of Professor Claeys' examples. So first is aesthetic zoning, and then second, the public use limitation in takings. So with regard to zoning, Professor Claeys argues that zoning should be limited to the prevention of harms, which can include invasive harms like pollution, but not aesthetic harms. So he identifies several problems with aesthetic zoning, but his core concern seems to be that aesthetic harms can't trigger the state's regulatory power because they don't impact how others use their property. But I've got to say, I kind of struggle to understand the natural law foundations of this point. So ugly buildings and unkept lawns, they don't interfere with other people's uses of property, but they do create genuine externalities. And having a neighborhood where all houses maintain a basic standard strikes me as the sort of regulation that does, in fact, secure a reciprocity of advantage for people who live in that neighborhood and in that community. Now, I can appreciate the underlying concern here. The key problem with recognizing aesthetic harms is that they have a tendency of being subjective. And if subjective preferences, as Professor Singer was noting, are recognized as a basis for limiting property rights, it becomes virtually impossible to police the limits of governmental regulatory authority. That seems right. That's a real concern. And it's similar to the problem of morals regulations. How do we figure out what counts as immoral? If morals regulations are valid, what are the limits of the police power? And so given the need to draw judicially enforceable lines earlier in the 20th century, lots of jurists actually cordoned off certain uses of the police power for exactly these sorts of reasons. Here, being concerned with institutional dynamics about how judges could police the limits of governmental authority. At least conceptually, though, I have a hard time recognizing why aesthetic harms aren't the sort of thing that can be recognized by certain communities under a natural rights framework. All of that makes me a bit skeptical that we can answer this sort of question by just focusing on reason. As I see it, whether aesthetic zoning rules advance the public good depends on a thicker assessment of the particular cultures and particular institutions within a given society, how much pluralism there is within a community, what sort of values members of that community have, how strong the democratic institutions are, and so on. So in my view, this is the sort of assessment where reason can only get us so far. And indeed, reason itself may point us in the need for community judgments about these sorts of issues. The other example, and the one I'll conclude with, is the public use limitation in zoning law. raised most famously in the Kelo case. So Professor Claeys argues that eminent domain power ought to be limited to takings that vest in the government or in common carriers, and not ones that are vested in other private businesses like real estate developers. As Professor Asbridge was mentioning, he makes an allowance for the government to intervene to solve private assembly problems under the police power. And again, I'm struggling a bit to understand some of the line drawing here, why it is exactly that we are going to ground these distinctions in understanding of natural rights and natural law. So Professor Asbridge has made some helpful points, I think, on the side of using the police power to advance the sort of assembly problems. I want to take the other side and think about why it is that we allow the government to claim the promotion of the public good whenever it takes property for itself or for common carriers. So why is it okay, in other words, to have takings that promote certain goods, like having better options for transportation, but not other goods like having better options for housing and jobs? Now, of course, as a matter of positive law, there's a really good answer to this, which is that we have a Fifth Amendment, and we need to figure out what the positive law limitations are that are embedded in the public use requirement. But for a project that's normative, we put aside that question of positive law, and we have to think about what justifies differential treatment of publicly conferred as opposed to privately conferred benefits. So Professor Claeys properly observes that public roads, public parks, governmental buildings all contribute to the public, to the common good. And I generally agree with that, but not every new road, not every new park, not every new governmental building is going to contribute to the common good. So, and we also at the same time need to think about the harms that are produced by taking property for those purposes. So both on the takings for private use, but also on the takings for uses by the government or by common carriers, we have a set of considerations that are practical and prudential that we need to evaluate. Professor Claeys is deeply attuned to these problems in the context of private takings. And I suppose I'd be open to an argument that within a given society and within certain institutional settings, there's reason to be more concerned about one or the other. But again, I'm skeptical that reason alone can get us there, that we can do this sort of process of natural rights and natural law reasoning without thinking more concretely about the particular institutions within a given society and without thinking about the particular values that members of that society hold dear. So thank you very much. Thanks.
Speaking next is Stephen Hayward, who is the Edward L. Gaylord Visiting Professor of Energy and Environmental Policy at the Pepperdine School of Public Policy. Professor Hayward frequently writes on a wide range of current topics, including environmentalism, law, public policy, and American political philosophy. Professor Hayward is the author of multiple books, including a 2-volume narrative history of Ronald Reagan and his effect on American political life, Index of Leading Environmental Indicators, and Mere Environmentalism are other books. Thank you, Professor Hayward.
Well, let me say it's a delight to be here and a delight for the Pepperdine School of Public Policy to be co-sponsoring the event. We do have a handful of joint JD and master students enrolled with us. And one of the things our program does differently than most public policy schools is that although we teach all of the traditional quantitative tools of cost-benefit analysis and regression modeling and all the rest of that, macro, microeconomics, we also emphasize very strongly the foundations of American constitutionalism, and in my case, it does mean teaching the natural law tradition as a preface for understanding the basics of legal process for non-lawyers, but people, if they're professional professional practitioners of public policy, need to have some familiarity with all of that. I'll say two things to get myself started off. One is I'm overpowered by Eric's book. It's so capacious that I haven't even come close to mastering it. But I think I can get out of my conundrum in the following way. My observations that I'm going to share are a nice bookend with Professor Mahoney, because there's some overlap, and so this is going to make a nice bookend for the people in the middle. And I think so. The first general observation is Eric's book is not just a capacious reconstruction of the foundations of property law, but I think it fits in with a wider revival currently underway of the natural law tradition. I was really delighted that it wasn't just another refraction of or refinement of takings law, although there's some aspects of that there. But for the longest time, I think it's fair to say that property rights, as a modern liberal natural right, so to speak, has tended to begin and end with James Madison's famous declarations from 1792 that a man is said to have a right to his property. He may be equally said to have a property in his rights. No man is safe in his opinions, his person, or his facilities, or his possessions without all those rights being thought of as a unity. Of course, he added in the next paragraph, where there is an excess of liberty, that would be, I think we can presume, when someone is potentially imposing a harm on their neighbors or their neighborhood. The effect is the same, though from an opposite cause. And we should always keep in mind that this is the same person who wrote in that most famous of the Federalist Papers that the principal task of modern legislation was adjusting the competing claims and clashes of different economic interests, which certainly includes the uses of property. So Eric is not satisfied with generalities. He says, I'll quote him here, when natural law and natural rights guide political and legal reasoning, they do so by supplying foundations and not formulas. But of course, he's trying to push us ahead to where we can find some formulas, because that's what practical lawyers and judges need to have, and legislators for that matter. Several of the speakers, I think, have said in here that we're trying to preserve or extend the latitude for discretion and judgments, the way I'd put it. And Eric says he's after the gaps between morality and law. Or, as I'd put it, bridging the gap between natural law and positive law. In fact, here's a couple of quotes from the book. In jurisprudence, scholars study whether and in what precise conditions a principle of morality might also include or might also constitute positive law. And he says this book brackets such inquiries. And then a few sentences later, readers may want to know whether natural rights are binding in positive law, even when controlling legal sources do not clearly incorporate them by reference. That question is sidestepped here, and I'll add that he has a nice footnote that he has written about these questions elsewhere, but don't want the book to be too long, I suppose, right? I want to take off the brackets and square off the sidesteps for a little bit and bring that back into view. I think one way of saying why I think this is such a remarkable enterprise can be best expressed by taking in the first sentence of the entry in the Encyclopedia of Social Sciences for Natural Law from 1968. I like this one because I think it really does state with directness the low regard of natural law, say 50 years ago. The quote, natural law, which was for many centuries the basis of the predominant Western political thought, is rejected in our time by almost all students of society who are not Roman Catholics. Now, I think this has all changed and well beyond the confines of the legacy Thomists who still walk amongst us. And I think here again, I'm in accord with Professor Mahoney. If you know the book from Stuart Banner from 3-4 years ago, The Decline of the Natural Law, How American Lawyers Once Used Natural Law and Why They Stopped, as he observes toward the end of the book that, in fact, there are a lot of the residues of the natural law tradition still with us. They never entirely went away, and they've come back in some ways that have been suggested. He mentions substantive due process, of course, which most of us are familiar with. He also has a good passage about how there were a lot of interest among jurists in the laws of economics, sort of the basic ones you learn in Econ 101 in the late 19th century, that I think do fairly well anticipate the much more rigorous and sophisticated law and economics school of the last half century, well known around these halls, needless to say. But we didn't use the term natural or natural law much anymore. And then there was an interesting study, I think last year, by a pair of law librarians called The Persistent Treatise. I'm not sure, it was on SSRN for a while, and I'm not sure if it's appeared in a journal yet or not, and I didn't go back and check. But what it was a search of cases in federal courts, but mostly the Supreme Court, from 1962 through 2022. I'll skip over the methodology, which has many weaknesses and I think places that deserve criticism. But what it found was that, and then what they defined as a treatise could be contested also. What they found is that the citation of classic treatises had declined and reached its nadir during the Warren Court, surprise, surprise, and has revived quite substantially in the last 20 years. And among those treatises are ones that I think legal historians would know. Bracton from the 13th century, Sir Edward Coke, Matthew Hale, the 17th century, Blackstone, and from America, Joseph Story and Chancellor Kent. So the numbers are, they were cited about 10% of the time in Supreme Court cases in the 60s and 70s. The last 10, 15 years, it's up to 25%. By reference, by the way, classic treatises were cited in about 60% of Supreme Court opinions in the first 20 years of the Supreme Court, starting in 1789. And of course, Banner is the person who says that the common law is applied natural law. That's a long subject, and I'm already down to like 5 minutes, I think. So I think that when I read the book about trying to find the links here, the gaps between natural law and positive law, I'm drawn back to a often forgotten short book from many years ago that I'm still fond of. It's Edward Corwin's Higher Law, Basis of American Constitutional Law. I should just say, I think the title is misleading because higher law and natural law are not necessarily the same thing. Higher law invites us to think about divine law, as Aquinas does, and I think that can be misleading. That aside, I think it's still a great book to read. But there is this confusing sentence that once we unwrap it, I think is quite helpful. He says this: before it was higher law, it was positive law. Before it was higher law, it was positive law. In the strictest sense of the term, a law in the ordinary courts in the settlement of controversies between private individuals. Now, I think you can see this as a restatement of the way Aquinas defined law in his treatise on law, that it's that law is discovered rather than being made, right? But that to be realized, the law must be promulgated. That's, in other words, set out in the positive law. In other words, natural law doesn't really exist until it can be stated in the positive law. And then, of course, by someone in authority with the care of the community. So there's a paradox, I think, evident right away. I'm explaining this too quickly and compressing a lot, and I apologize for that. But any theory of natural law that affects property or any other natural right begins as a limitation on authority or legitimacy of government to control those rights. So we're suddenly starting to go in a circle, I think. Now, I think Eric gets us onto a lot of avenues into some solutions to these. I think I'm going to skip over to closer to the end of my notes. So Professor Mahoney hinted at this, I think, or at least I took part of her comments in this sense. One of the debilities of natural law in modern times is the suspicion that either it's divine law and or that it's dogmatic, that we're looking for some fixed, inflexible rules, like the Ten Commandments, which even those are not necessarily fixed and inflexible or susceptible to different applications. And that's been one of the, I think, mistakes in the natural law tradition that goes back several centuries now. In fact, maybe you can say that the person most responsible for it is Aquinas. Now, for my sins, let's see, I've got a couple minutes left. For my sins, I've lately been reading a dense and difficult German philosopher, although I could probably just say German philosopher, since dense and difficult is right, sort of presumed, named Hans Georg Gadamer. And he wrote a lot about hermeneutics 50 years ago or so. I'll have to say he's much more interesting to read on hermeneutics than all the French hermeneuticists, if that's a word. And so he talks about hermeneutics for different literature, theology, reading the Bible, philosophy, but also he has several very interesting pages on the hermeneutics of reading legal texts. But before long, he has to get all the way back to the beginning, which is Aristotle. I'll give you one sentence of his that I think is kind of fun and is thought-provoking. He said this: legal positivism. By the way, this was 1960. It was first published in German. Legal positivism, which would like to limit legal reality entirely to the established law and its correct application, probably has no supporters today. Now, that will strike you as like a ridiculous statement until you understand that he has in the back of his mind a distinction between positivism as we know it in the social sciences and legal positivism, which is different and distinct, but that also gets jumbled together, I think, in the public mind a lot. And before long, he says, I'll just one more quote from him, there cannot be in Aristotle any such thing as a dogmatic natural law, because nature entirely determines the whole human world and consequently also the legal constitution. Here I'm stating perhaps too abstractly, but I am quoting a translated German, what Professor Singer was saying about practical reasoning and consequences and circumstances. And a little more from Gadamer, he said, it has always been felt to be shocking that Aristotle distinguishes between conventional and natural law, yet he goes on to claim that natural law can be changed. This is, if you know it, and I don't have time to go through it, the famous chapter 7 of book 5, the Nicomachean Ethics, where Aristotle says these very curious things about, some things in natural law really are fixed. He doesn't say dogmatic, but nature is changeable. And then he says, but we'll have to put these questions aside to a later date. And if he ever wrote that treatise, it is lost to us. And so we're left to reconstruct it on our own. And so the point I'm making here is that I think Eric may find this sort of bizarre outre, but I think Eric and Gadamer are engaged in a similar task to recover a latitude for jurisprudence in his particular taste property, but I'll bet if we expand our minds, it can be seen to apply in other areas. But he wants to recover a latitude for jurisprudence that was too often constricted, first by sort of neo-Thomistic teachings, and then also the modifications of modern liberal social contract theory and natural rights theory that have been brought up. But alas, I am out of my time, and I thank you for yours.
Thank you, Professor Hayward, and thank you to all of our panelists who just gave wonderful presentations. Last but certainly not least, I'm going to introduce the man of the hour, Professor Eric Claeys. Eric Claeys is a professor of law at the Antonin Scalia Law School at George Mason University. Professor Claeys has authored more than 50 law review articles, including Takings, Regulations, and Natural Property Rights, Labor, Exclusion, and Flourishing in Property Law, Property Concepts, in Functions, and Assembly, Public Use, and Reciprocity of Advantage, which is forthcoming later this year in the Yale Journal on Regulation. As you've been hearing, this year, Professor Claeys published his first book, Natural Property Rights, and we'll be speaking on that next. Professor Claeys.
So I want to thank Steve, Judd, Jessica, Joe, and Julia for their remarks. It was very generous of them to give as much attention as they did to my book. I want to thank George Mason University and 3 deans and the law school for supporting my crazy research on this for like 15, 20 years. And I want to thank the Pepperdine School of Public Policy for co-hosting, and I want to thank Peter Tucker and Nick Rodriguez for agreeing to publish the proceeds of this conference later this year in the George Mason Law Review. It is an overwhelming task to hear the kinds of comments from the range that you heard from 5 different people, and I've got now 14 minutes and 15 seconds. So what I think I'm going to try to do is to restate the basic argument of the book and then address some of the more important challenges or questions that the different commenters raised. but I'm sure I'll miss lots because now I have only 13 minutes and 55 seconds left. But I guess before I do that, though, pardon the promotion. So the book was just published in May with Cambridge University Press. You can buy it now for $140. If you want to buy a Kindle version, I think that's for under $40 now. If $140 is too rich for your blood, wait until May next year. The softbound ones will be out for, I think, $40. So 3 different purchase options. But what will you read if you purchase? So the book has 4 main parts. The first part is I'm trying just to make natural law reasoning seem less ominous, to get rid of what one of the readers called its bad odor. And so that part's called Foundations. And I'm basically trying to argue in that part that natural law sets out standards for right and wrong that are connected to human survival and well-being. And those can help us think about natural rights we have in different parts of our lives. And those rights can provide useful benchmarks or targets for us to work with as we reason about lots of different things in ethics, and then more so in social morality and in law. And so I beat to death in that part, and then I beat hard later on the idea of a speed limit. It doesn't take that much reasoning to start from natural rights to life and to property and to travel and see that a speed limit is coordinating some people's rights to travel consistent with other people's rights to be safe in their persons and in their property. And the natural law can tell you there ought to be some reasonable coordination among those 3 rights, but then you need specific positive law to give you numbers to make clearer and more effective in practice what the natural law is suggesting ought to happen. And so a couple of thoughts in relation to things that different of the readers said. So Judd mentioned that one of the functions of natural rights is to legitimate law, and there I'm very much with Judd. So a natural right to travel, a natural right to life, and a natural right to property set benchmarks for asking whether a particular speed limit is a just exercise of government authority. A speed limit that is too tight for a long drive, that's unjust because it's restricting the right to travel. One that's too loose in urban neighborhoods, that's unjust because it's threatening people or their possessions. And here also, I guess, some of the comments, Jessica's to some extent, Julia's to some extent too. There's a lot of interest in this book in the takeaways for constitutional litigation, and I care about those topics, but I don't care only about those topics. And I hope that this book, it enriches discourse in a lot of different arenas. Natural law, natural rights can be used in democratic argument. And so I'm sorry that Joe found the book focused too much on rights, not enough on democratic discourse. I hope that rights can provide benchmarks in democratic discourse, and they have been at different points. I mean, the abolition movement was a democratic project. And the civil rights movement was too. And property rights debates can be had in legislatures just as much as they can be had in courts. And I guess a couple of other thoughts here. Julia and Steve in particular stressed that these kinds of rights are rights that are accessible through human argument and human reason. They're not necessarily divinely mandated rights. I don't think they're inconsistent with rights that you can understand from divine revelation, but they're not necessarily justified on those grounds, and you don't need to justify them only on those grounds. And the last point, I guess, on foundations, Joe had worried that rights might crowd out obligations. And I share that concern much of the way. There may be a little bit of residual disagreement between me and Joe that will never go away. But the way, if rights are consistent with natural law, the natural law tells people how to live good lives. And once you know how people live good lives, people have some obligation to do what might be good and some obligation to respect others' chances to pursue what's good. And so the rights and the duties in legal practice end up being complementary, and they're both derivative of what's good for people. And so I don't think that, I reject the idea that at a deep level, the rights are more fundamental than the duties. The rights and the duties are both derivative of human well-being and human survival. Now, in Chapter 2, I stress, I think there are a lot of sensible reasons in practice to make rights primary the way they are in the Declaration of Independence and declarations of rights in states' constitutions. And there, the idea is that each one of us is our own best advocate, and better to have a political discourse that reminds us to assert our interests. It's why is the government telling me I can't do what I think is for my well-being? If choosing between people being spoiled because of too much rights talk and people being meek because there's too much duty talk, I'd prefer suffer with the errors of rights talk to have all people be more spirited and capable of standing up for themselves. So then, once I've worked out I've gone through natural law, natural rights, and why they're not so spooky, as I put it, I turn in part 2 to property and the natural right to property. And the natural right to property, I think if you reason about it, it's a right in a resource that is not a person or something that is inextricably tied up with a person, like a reputation, a name, or a body. And for those things, people are naturally entitled to keep using a resource for human well-being that they've started to use that resource. And as long as they use the resource in a manner that performs a function I call in the book claim communication. The use gives others reasonable or courteous notice that the user wants to keep using the thing. And so to get a natural right in a resource, you have to use it for survival or thriving and signpost to others, I want to use this for survival and thriving. But then the right is limited by others' equal opportunity to acquire their own resources. And this is Locke's enough and as good proviso, or in Catholic social teaching, the community of goods. And then there's a limitation for the cases of necessity when one person really needs a resource in an emergency condition. And that right serves as the benchmark or the measure for reasoning about positive law, the same way a right to travel and a right to life and right to property do for speed limits. And so here, this is a good place to take up another one of Joe's concerns, that values are subject to change. And I take that criticism to a point, but only up to a point. I guess what I'd say is the imperatives about encouraging use and making owners and proprietors communicate their claims, those are permanent and natural. The way those get operationalized in practice are, in fact, subject to change depending on lots of local conditions, the kinds that Joe talked about and Judd talked about. And so at the founding, there were a lot of limitations on the right of exclusive control associated with trespass because people had rights of way to go forage for land or for animal, for sticks, to fish on other people's property. And then land got enclosed over the 19th century as there was more farming. And maybe things will, then we changed things later once there was air travel. The air column before had been pretty rigid and then it became more permeable. And we're going to have to go through this all over again once Amazon and other companies trying to convince us all that the overflights of drones isn't that much different from an airplane. These are the kinds of use and claim communication provide the two basic things you need to be talking about and asking whether drone rights are consistent with people's rights of exclusive control. And they provide a framework for a reasonable argument about how you fit drones in. So then the third part of the book turns to property law, and it tries to cover all the guts of the private law of property. And so here it's why have private property at all? There are some cases where the best way to facilitate the beneficial use of resources is to have the resource owned by the government or in a common. And then how do you design particular property rights? So property lawyers know coal runs with the ownership of the oversitting land. Oil is a separate resource. Why are those two treated differently? And the answers have to do with you package rights differently as seems to facilitate use and claim communication. And then there's a whole welter of questions about how do you take a right to use and morality and turn that into absolute ownership and a right to exclude in legal practice. And you can justify a right to exclude in practice for morality, but there are going to be limits. And so part 3 tries to run through those. And I think that way of thinking is rich, it's dynamic, and it addresses a lot of the issues in the private law. So I'll take one. Joe worried that the kind of approach I'm justifying can't deal with the mistaken trespasser who improves a structure on someone else's property. So I cover that in chapter 9 of the book, and the account goes something like this. There are lots of reasons why giving people sovereign-like managerial authority over land helps them better to use their land and makes clearer for everybody else who has power to do what with land. But then if one person mistakenly puts a structure on someone else's property, if the person does that in a genuine mistake after careful research, that's not a person who has the kind of state of mind, I'm trying to disrupt someone else's property rights. So there's something understandable. That person's now built something of beneficial use, the structure, and where there was before vacant land, the land was not beneficially used by the owner who it was trespassed on. So there are some details to then fill in about how you work out the kinds of the accommodations, but you have a broad positive law right to exclude, qualified by a limited liability for the mistaken trespasser who mistakes in a good faith and careful mistake. Now, a lot of the action in the comments focused on is part 4 of the book, how property law relates to the private law and more so to takings law and to public law more generally. And I guess here, there's probably more than I can say in the 3 or 2.5 minutes I have left. I guess I'll say a few things. First, I hope for this part of the book to give guidance about how political debates about institutions like zoning and how institutions like economic development statutes, how legislatures design them. I hoped also that the same chapters would give advice to judges and lawyers who are trying to work out the details of regulatory takings doctrine and eminent domain doctrine, as you heard about. I guess I'm more optimistic than Judd is that these standards can guide practice. But Judd does catch me in that to an extent, in that in these chapters, I try to throughout the book, get across the idea that natural law and natural rights set general standards for the way people reason about things, and they leave considerable discretion for lawyers, legislators, and judges to fill in details. And in trying to make this relevant to takings doctrine and eminent and public use doctrine, maybe I start to be dogmatic and say the abstract principles mandates particular results. There's a possibility I got too much into the details from the abstract principles. I guess I want to close by taking up one of the examples that came up a few times. That's about aesthetic regulation. And so here is the way the principles about property rights guide principles about police regulation and public law, I think, in 3 layers. So the first question to ask is whether a police law is doing something to coordinate private rights in a manner that seems considerate with the rights of all the other people. And so with aesthetic regulation, the question I think you'd want to start with is, when a community institutes a law saying a certain kind of use of land is ugly, does that judgment secure an equality of rights? And the way you have to think about this is that the rights that the government ought to be trying to secure are rights that are fairly general and fairly homogeneous, so that it's secured to many different people, it's discretion to do lots of different things. And if there's a general principle in the law that if one person finds something ugly, the question to ask about it is, how can the government operationalize that in a way that leaves everybody with general, fairly homogeneous, broad discretion to do what they want? And my concern, I guess, is that a right to complain about eyesores gives a lot of different people discretion to complain to the judge in a nuisance case, the zoning commission and a zoning board, to say, I don't like what that person over there is doing. And it forces local arbiters to judge between one person's dislike and one person's aesthetic use. And instead of having a system in which the government's trying to enforce relatively generic rights that let people do what they want, whatever those things happen to be. So the concerns about aesthetic regulation at a high pitch are the kind of the concerns about hate speech laws. If a hate speech law that lets one person say, I'm offended, make that other person stop speaking, it diminishes everyone's speech. I worry that aesthetic regulation is similar. That's not to say that a government cannot act on aesthetics, but what it should do is to say, if the government wants to make an aesthetic judgment, what it needs to do is to say, we want to stop a certain set of uses so that the whole public can benefit from whatever aesthetic benefits come, and that ought to be treated as a regulatory taking. That's just one of like 20 or so hard questions that could be asked about the chapters about takings in eminent domain. So maybe the best thing to do is for me to thank everybody again. The authors, the readers were very generous in their comments and their critiques, and I'd love to hear from people in the audience.
So we have just under 20 minutes for Q&A. So we have microphones lined up on each side of the auditorium. If you have a question, please line up. And we would love to hear from you. I see many of our distinguished faculty here. I'm certain that you all have some questions or comments, so please line up. We'd love to hear from you.
And can you please identify yourself and your affiliation when you ask your question?
Hello. I'm Lyle Weinberger here at George Mason Scalia Law. Great conversation, so many things to talk about here. One that I wanted to press on that seemed to tie together several threads is this relationship of common law, natural law, in the kind of working out of a local community, and whether we have kind of a wiggle room for the articulation of natural rights, whether there's room for democratic debate. These are two things that have been very controversial in American history, as I think Judd has encountered in his work. How much is the natural law, how much does it feed into the common law? And how much is the idea of a lot of this being articulated in courts maybe not a great forum for democratic development? And Eric mentioned the possibility that this doesn't have to be just courts. So I would love to hear thoughts from Eric and others on that common law, natural law intersection.
I'll take first crack, in part because this is one of many reasonable reactions that the readers gave I didn't respond to up on the podium. So I guess my first take on this, going to some of what Steve said, I'd start with Aquinas. So for Aquinas, law consists in its central sense of, or its simple sense, of an ordinance of reason directed to the common good, made by the community or one in care thereof, and is promulgated. And so legislation, the community delegates to a legislative body to make laws. But then the common law, the way to understand it in this sense, and Aquinas has an article on custom that is it's often left on the cutting room floor of short versions of the treatise of law in book form. But so law can be made by custom, and the common law, I think, is understood that way. And so the common law judges in the English tradition saw the common law coming out of some combination of judge prescription and customary practice. And so then the idea of the common law at its root is some principles of natural law that a community has accepted, and then common law decisions or applications of those basic principles in a lot of different settings. So then you can have a system that has both legislation and common law as long as the judges understand what they're doing to be the working out of basic principles of natural law, and they're staying within what's customarily acceptable in their community, and that they also respect the idea that when legislatures speak on these same topics, then the common law needs to be overridden. That's a first cut.
I guess, let's see. I guess I could add two thoughts. One is, I'll try it this way. The process for, over a century at least, if not longer, to codify more aspects of property law and other areas of private law is to regularize things that were discovered in common law, especially when the legislature might say, we're not sure we like that rule, or it doesn't adapt fast enough to changing circumstances. So that's one part of it. And the result of that and other things, and also the decline of the natural law vocabulary, the way I put it is, it's left us with law that's full of verbs, but we've lost the nouns and adjectives. Now, sort of a related point, if you go back to, I'd be interested in your thoughts on this. I mentioned the persistent treatise study that said that 60%, I think I said, of the Supreme Court decisions in the first 20 years cited some old treatise, said, it's Blackstone and some of the ones that were mentioned. What I noticed about a lot of those early cases is, first of all, they didn't have any of their own precedents yet, right? The Supreme Court starting out with all the, nowadays you work by what precedents we're working from, we're going to modify, of course. And so they were kind of on their own. And so they could look at English common law. That's especially Fletcher versus Peck is my favorite. I don't know if Fletcher versus Peck is still taught in a lot of conventional law school constitutional law classes or not, but a lot of discussion on, does the British common law help us here? Well, here's parts where it does, and here's part where it doesn't. Marshall finally says, but contracts are contracts, and right, one of my, that whole the land fraud aspect of that case is so much fun. But I think it was which one of the associate justices said, we might not have to go to the text itself to solve the. There might be, it's Johnson, thank you, that's right. The passage I'm groping for and I'm not getting it, it's not coming to mind right now. But he says, we can decide this case on the general principles of law themselves. He means natural law reasoning, right? He said, I actually wrote a little article about this recently about, what does he say in there? He says, principles that bind even God himself, which I thought, that's an interesting theological claim, but leave that aside for some other day. So by degrees, that all gets replaced by both codification in certain cases and also by the fact that they're starting out having a body of precedents you can work from. So we still do teach McCulloch, right? But I remember when Kelo came out, and I ran back right away to that passage in Calder versus Bull, where you have a big, vigorous argument between Iredell and the others about can we appeal to natural justice, it's natural law. And I forget who, but one of them says, well, of course it would be wrong to take property from private party A to give it to private party B. And then, lo and behold, we get to Kelo, I think because we had forgotten the ground of that principle. Sorry,
Others or next question?
I just wanted to say, as I've gotten older, I found myself getting very emotional teaching my students about common law, first-year students. And one of the things I say to them is how democratic it is. And what I mean by that is if you are injured by someone else or someone did something that you think you have some legitimate claim against them, you can try and make analogies to existing law, but you don't have to. You can go say, look, somebody did this terrible thing to me. I think the government should do something about it. I think I've been wronged. And if you go to the legislature, they don't have to listen to you. But a judge, they have to listen to you. And the idea that anybody can force a government official to hear their problem, I think it's just an incredible institution. And what people say in those instances is arguments about morality, about what we owe each other. And I don't really care whether you call it natural law or not, but if you just read common law opinions, and property law opinions are an example of that, you just see over and over again discussions of fairness and liberty and justice and welfare, and it's just, you're filled with the legitimate interests that Eric, that you write about. The judgments are just replete with all of that stuff. And the judges are trying to figure out what is fair within the relation between the parties. And it's true that if you come up with something frivolous, they'll throw you out and there might be malicious prosecution. But generally, people go to court because they feel a moral injury. And the judges have to listen to them. And they can't just say, I can't find a law to govern that. They actually have to say plaintiff wins or defendant wins. And then they have to give a reason. And I spend most of my time, first semester, I'm teaching property right now, teaching the students what a holding is. And you can't just say, this person wins. You have to have a general rule, and it has to be something that can apply in similar cases in the future, and you have to be able to defend it. And I think the common law is just filled with normative judgments, but it's also, in that sense, quite democratic. And a lot of common law decisions are subsequently codified. And we go back and forth. There were housing codes, and then the judges introduced the idea of implied warrant of habitability, because the housing code didn't think about what that did to the landlord-tenant rights. And then the legislatures looked at that and said, oh, that's a good idea. And then they passed statutes codifying the implied warranty. And I think courts and legislatures teach each other, and there are advantages to the court lawmaking process and disadvantages, and the same thing's true of legislatures. And I think they teach each other and work together in a system which is better for democracy than if we only had one of them and not the other.
I might,
For those comments, Professor Campbell.
I might add one quick overlay here. So I didn't bring this up in my comments because the book is not about positive law, but when we're thinking about, so Professor Mahoney mentions takings and the court's recognition that an earlier understanding of takings doctrine would have accepted some baseline, and that's a problem when you move to a positivistic conception of the common law. But there's a kind of related problem that I think the court is not appreciating, and it dovetails nicely with what Professor Singer just said, which is it's not just that the underlying state law would have been grounded in common law, it's that the principles of takings law themselves would have been thought of to a large degree as principles of general law, which means it's not exclusively up to the Supreme Court of the United States to articulate what those are. It's a question of general law that requires discourse across jurisdictional lines. And so there should be, in an earlier understanding of law, a greater interplay of state and federal judicial decision-making and perhaps even legislative decision-making that develops out principles of takings law rather than having this sort of top-down national approach. And so I do worry that that's lost as we move away from this earlier notion of common law towards the idea that federal constitutional law is exclusively up to this jurisdiction, state constitutional and common law is exclusively up to this jurisdiction, and so on. It's not just about the underlying definition of property law, it's also about the definition of the public law limitations that apply.
Yeah, just a quick question. Don't you see that playing out in takings law now? Exactly what you're describing. Because the search for the background principles, for example, it's not just an anti-circumvention strategy. I think it's genuinely a search for substance.
Right.
For a higher law.
Yes.
All right, let's go to our next question over on my left.
Hi, Dan Greenberg with the Cato Institute. Professor Claeys, I wanted to ask you about a very minor theme in your remarks. You briefly mentioned the intangible right to a reputation, which I take it you see as something like a natural property right, or a part of the scheme of natural property rights. Do you understand defamation as possibly intruding on people's right to a reputation in this tradition? And I wanted to ask you, is there a tension between that and the modern line of cases, starting with New York Times versus Sullivan, which understand defamation and defamation that has a remedy in a very different way? Right now, there's no remedy for non-malicious false statements, and I wanted to ask you if there's any way that this line of cases can be reconciled with your understanding of the natural property rights tradition.
So thanks for the question. A couple of thoughts. So the question is something that I'm ducking in the book, but I don't mind because my next article project is going to talk on this a bit. So I'm doing an article about the police power, and I'm going to look at the way the police power was understood in right to bear arms, speech, and property cases. It's not in the, I don't cover this in the book because the right to reputation, I don't think of that as a property right, that's a personality right. So I borrow here on scholarship by an analytical philosopher trained in England, James Penner. He argues that property is a field for resources that are called separable resources. They're in principle separable from people. They're not essentially part of what it is to be a person. So your body is inseparable from your person. Your identity is inseparable from your person, but a stick is separable. So reputation is part of what it is to be a person. So it's a personality right, not a property right. So it's out. I don't cover it in the book, but like from my armchair opinions about like a right I haven't studied a lot as a scholar, a right to reputation. It's a right of personality, but like all other rights, it needs to be aligned with all the other rights out there. So one person's right to speak needs to be harmonized with another person's right to reputation. And so if someone says something that is false, that hurts someone else's reputation, and there's not justification to say it, then that is a abuse of the right to speech to harm reputation. And if you look at Story's commentary on the Constitution, what he says about speech, and you look at the case law going back from the 1790s through the 1840s, they take for granted the right to reputation has to be reconcilable with speech. And state constitutions from before the Civil War, they mark off limits on the right to speech in the Constitution for reputation. And it makes me skeptical that New York Times versus Sullivan is consistent with original meaning.
Hi, Chase Masters, George Mason law student. George Mason's a school known for its strong tradition of law and economics. One famous theory coming out of Mason is that of rational irrationality. I was wondering if you could say a few words about the natural rights, limits of rationality, and democracy in the shape of the law.
So I'll take a crack at this. Earlier drafts of the book said a lot about this because I have so many colleagues on the Mason faculty who asked this question. And then I did book manuscript workshops. I remember Joe and Julia being on one where the strong advice is cut that out or put it toward the back. The readers who are most interested are not going to be interested in that. So, but I'm happy to resurrect some of the things that were on the cutting room floor. Chapter 1 covers this quickly, and then there are a couple of other chapters that cover it in a little bit more depth. So there are circumstances in which law and economics is an acceptable way to analyze positive law rights and ask what rights are the best rights. But law and economics has to be conducted within certain moral parameters. And oversimplifying quite a bit, the two basic questions I think are these. You need a theory of justice to tell people what pre-political entitlements they have before you can start imagining hypothetical Coasian bargains with those entitlements. And people can bargain with some preferences, but not others. Some preferences are vicious, spiteful, irrational morally. Others are reasonable preferences. So then Adam Smith agreed with everything I just said. And if you look at some contemporary law and economists today, they do too. So I quote for all it's worth in The Mission Against Interest by Bob Ellickson, a professor of property law at Yale. There's a footnote in his best article, for my money, where he says that cost-benefit analysis of a system of land is circular without an account of the pre-political entitlements on which the analysis is going to take place. And he cites to Frank Michelman, a colleague of Joe's, someone who's a careful lawyer and a careful defender of philosophical rigor in law. And so I'm with Ellickson. Economists who reject the idea that some theory of justice tells people what pre-political entitlements they have and what kinds of preferences are rational to work with, I have more of a quarrel with. And to them, the challenge becomes, why is for them law efficient in a way that the government can force people to go to jail for not following the law? And their two main arguments tend to be wealth is good and efficiency maximization is good. There have been a lot of philosophical scholarship criticizing those two views.
And with that takes us to time. Before we conclude, I want to first thank the wonderful panel that we've had here today of leading scholars in their areas of law. I also want to congratulate Professor Claeys on publishing Natural Property Rights. it's a wonderful book, and it's a notable accomplishment. I know he spent many years working on it, decades even. And I also want to recognize Professor Claeys' continued contributions to the students here at Scalia Law. Professor Claeys takes numerous students under his wing and trains them and teaches them quite a bit about property law and takings and the common law, and I'm one of those students, and I'm extremely grateful for the time investment that Professor Claeys has given me and all of the students here at Scalia Law. Your impact will long continue after you have retired. So thank you for that. Thank you all for attending today's symposium on natural property rights. A reminder that the reception will be at 4 p.m. in the Leadership Center, which is Hazel Hall, room 150. Thank you all.